statutory construction.
Mr. Vasu.
Members, this is the bill we talked about extensively last night. It just makes sure that when the legislature passes the law, it's interpreted according to its plain and ordinary meaning. Move passage.
Ms. Rodriguez-Ramos in opposition.
Thank you, Mr. Speaker. Members, I rise today to speak in opposition of, thank you, oh, thank you. I rise today to speak in opposition of 113, but to also sound an alarm. We are witnessing in real time a dangerous shift in how our government works and who it works for. HB 113 may come to us dressed in legal jargon and dry statutory tweaks, but its implications are seismic. It is the quiet implementation of a radical vision to dismantle the government as we know it, piece by piece, starting with the rule books and the referees. Let me be clear. This bill is a power grab, one that hands unelected judges and corporate lawyers the pen while it rips it from the hands of the legislature and the people who sent us here. HB 113 erases the voice of us legislators. It tells judges, don't bother looking at what the author said, don't review what the committee found, don't consider what we debated and amended in this very chamber. The only thing that matters is what's on the page. And if that page is unclear, which is often the case, then the judge holds all the power. Legislative intent erased. The historical record banned. Agency expertise ignored. Let me ask you, who benefits from that? Not the families in Dallas trying to understand changes to health care benefits, not the small businesses in El Paso needing clarity on environmental rules, not the school district in the Rio Grande Valley trying its best to follow the law. No, this benefits the same ultra-wealthy anti-government operatives who have been scheming to gut our public institutions for decades. The same billionaires who celebrated when the Supreme Court overturned Chevron last year. You don't have to take my word for it. Look at what this bill does. It prohibits courts from giving weight to how our state agency experts interpret the very laws they are tasked with enforcing. It prohibits courts from considering what we, the legislator, intended, our floor debates, our committee reports. It rewrites the rules of severability to say, even if a law is partially unconstitutional, courts must uphold every scrap that remains. And it repeals every government code section that tells courts to interpret statutes reasonably and with an eye toward the legislative purpose. I serve on the House Committee of the Delivery of Government Efficiency. Our charge is to evaluate agency performance, to root out waste. This bill is not an efficient bill. It's designed to gridlock our government and then throw the power to the judges. This bill silences the legislator. It sidelines the agencies. It leaves everyday Texans to navigate a legal minefield where the rules are no longer guided by democratic input or expert interpretation, but by the whims of whichever judge hears the case first. This is about consolidating power into the hands of a few. This is a pattern, this is a plan, and we know the name of the plan. We've been talking about it for months. This is Project 2025 Alive and Thriving in Texas. We've seen other bills that carry out this Project 2025 banner. Bills which hand sweeping control over state agencies to a new office under the control of the governor, letting him rewrite agency rules, override public input, and dictate policy from the executive branch without accountability. It's an authoritarian dream come true. Dismantle the administrative state and replace expert governance with political loyalty. Other bills, if you remember, which in textbook Project 2025 fashion, strip decision-making away from the independent career civil servants who have subject matter expertise and placed it into the hands of state office administrative hearings, administrative law judges, under the control of the governor. Bills like HB 229, which we debated fiercely on the floor just 2 days ago, which follows the Project 2025 call to roll back recognition of gender diversity and target our trans Texas siblings. And now HB 113, gutting how laws are interpreted, enforced, and defended. And let me say this, Some might say I'm getting off topic, that I'm speaking out of line, but I say this is the topic. If HB 113 bill passes, the intent behind every future law we pass, every amendment we fight for, every floor speech we give may be declared irrelevant. So while the record still matters, I want this moment to be etched into it. Texas families deserve a government that listens, responds, and respects their voices, not one where billionaires buy the rules and governor-controlled judges write the laws. In our Texas, the one I believe in, we respect the rule of the people. We trust public servants who dedicate their lives to service, and we make laws that reflect the will of the people and not the agenda of the privileged few. I will not quietly consent to the dismantling of this body's authority. I will not stand by while we turn over power to far-right courts and billionaire interests. As Timothy Snyder wrote in On Tyranny, do not obey in advance. Let this be our line in the sand. Stand in opposition to HB 113. Stand in opposition to Project 2025. Stand in opposition to this regime. Thank you.
Mr. Diallo, for what purpose?
Will the gentlelady yield for questions?
Generally yield for questions.
I do yield.
She yields for questions.
And I'll be brief. I was listening to your remarks, and I heard you say once or twice that this bill silenced our voices, our legislative voices. And that took me a little bit, because would you not agree with me that once our legislation becomes law, those words are our collective voices? Would you agree with that?
To a certain extent, but once again, the background of what went to creating those laws. We say it every day. Can you reduce what we said, the comments in writing and place in the journal? There's a reason for that. And in fact, words matter, right? And words have different interpretations. It's like the philosophical saying, you never step in the same river twice.
So my question, just to focus on my question,
Yes.
is that statute, that law, reflects our collective voices in this body. That's a true statement, right?
To a certain extent, I don't agree with all of it, but
But
to
my
a certain
words
extent,
back here, what I'm saying today is not our collective voices. These are my comments about certain legislation, and they don't reflect the body, correct?
what you just said,
Yes.
we're talking about clarity of what the law is, right? The words on the paper, which is what this law allows. And for that to happen, for that interpretation to happen, we do need to know background. What you just said right now is not relevant to the law, right? But when we have these discussions and these debates for clarity on what the intention is or what have you, those words do matter. That interpretation, that discussion does matter, and it is valuable discussion. If that is the case, then there would be no point in having no discussion. There would be no point in sharing and educating the public, and that's what's important about this dialogue, is that we are not only informing ourselves and educating each other, but we're also educating the public, and there's value to that.
What we hope to do, and I've represented litigants for 33 years, and what we hope is that there's predictability in our laws, that someone can look at them and say, this is what they mean and this is what's going to happen, and I can predict, I can anticipate what my action or inaction is going to result in.
Well, and you just...
Let me finish.
Yes, sir.
And this is what this bill is attempting to do, is to provide more certainty in our legislative process and then in our litigation process in the future. Would you not agree with that?
You know, you just said it allows us to provide certainty because the words on that paper are all that's going to matter. It reminded me of a comment that the bill author made yesterday. He said, this is a very conservative bill. Not conservative as in politically conservative, but conservative in the way we're going to approach interpreting these laws. And the mere fact that he had to make that distinction in explaining the rule or the bill, the mere fact that he had to make that distinction on the microphone further emphasizes what I'm talking about. He's saying, using the term conservative in two different ways. So if I saw that on paper without looking at background on that, what the statement was, then I wouldn't be able to interpret it according to what the author said.
We'll just agree to disagree. Thank
Yes,
you
sir.
for the
Thank
dialogue,
you.
though.
Yes, sir. Thank you.
Mr. Speaker,
Alice, for what purpose?
will the gentlelady yield for a couple of questions?
Generally yield for questions?
I do yield.
She
Thank
yields for
you.
questions.
We're both lawyers. As a practicing lawyer of 20 years, this bill concerns me because we both know that laws made two ways. It's either the legislature or judicial law. And laws rarely that we make are exhaustive in their explanation of what they mean to the fullest extent. I mean, obviously, we'd have buildings and buildings full of books if we tried to do that, and we still wouldn't be exhaustive. So it concerns me because this is how law is made, and judges rely on attorney arguments. And sometimes when a law is unclear, it's very common that we go to the legislative or the intent behind any law to understand better what the purpose of it was. And why is that important to everybody in this room and everybody in Texas is because that then gets interpreted of how that law affects you as an individual. And that's my concern mainly with this bill, is that if we don't have legislative intent for judges and attorneys to look at, then it becomes a subjective gymnastics where it's just an individual saying, I think this is what this means, and I think this is how it should be applied. Would you agree with that? And is that the drive of your concern?
I do agree, and we know that everything, we don't live in a static space, right? Things change, times change, and certain circumstances are situational. And so when we introduce the law today, there may be things that are different. There will be different things that happen in the future that we won't be able to apply. A judge won't be able to apply what was going on at that time when that law was drafted to realize or to emphasize or to interpret how to exercise that law or how to enforce that law, because we're not allowed to look at what was happening at that time and place. And so it's not a good direction for us to move forward as a legislature.
Good. Yeah, I think we're both saying the same thing, and I appreciate you rewording it that way. And then the last thing I'll just ask is, do you know, as a practicing lawyer, how long the judges and attorneys have relied on this tool of legislative intent to bring arguments and to make decisions in the court?
Well, it's from the beginning of our country, right? Over
It's
250
forever.
years.
That's really my point. Thank you.
Yes, ma'am. Thank you.
Mr. Speaker, does the gentlelady yield?
Generally yield for questions?
Yes, I
She
yield.
yields for questions.
Thank you. Just to follow up with that, drafting legislation is a really tricky endeavor. I've worked on that at certain agencies, and we've tried to commit to paper those precise ideas that we have and want to make sure that you are as precise as possible. But in any event, you can never quite get the meaning that you want all the time. And we're trained as lawyers, and a good lawyer is always going to question what exactly the meaning of those words, even though you've tried to be as precise as possible. They're always going to question, are they not, what those exact words mean? So
Absolutely. And in fact, I'm glad you mentioned those exact words, because many times when we have a bill author come up here and explain the bill, you have probably experienced this many times. We ask the author, what does this mean? Where did this come from? And many times they say, I'm not advised. I'm not advised. So if they themselves are not advised, how are we to empower and allow judges to interpret or to enforce, to interpret the laws that we're drafting when the own bill author is not advised? Many times we hear that all the time. And so if they're not advised on the letter of the law that they are themselves drafting, how are we expecting for judges to interpret that law when we're not allowing them to use background information, discussion, and dialogue, committee reports that we've had in drafting that law?
yes, and correct. And if it weren't, even wordsmithing is a very difficult art. And even the best writers will struggle with getting what you're trying to get across in a piece of legislation when we ask legislative counsel to draft our bills, and they say, well, maybe, but that's not quite exactly what I meant, and maybe it can be interpreted to mean something different. So you got to make sure, and it does take precision, and it's important, I think, and I'm sure you would agree, that you would need to be able to look at the testimony and look at the discussion that was had on those precise meanings of those words that you intended to put on paper. Is that not correct?
Yes, that's right. And you mentioned earlier, as attorneys, right? We look, what's next? As attorneys, there's so much that we're trying to interpret that we even look at case law, right? When we're trying to fight a case in court, you're looking at case law to figure out what that means. And so, what's next? Are we going to now in the future get rid of case law as well, and not be able to reference case law to be able to determine what those words mean? I mean, that's the whole purpose.
The gentlelady's time has expired.
Oh, I'm sorry. Thank you.
Thank you.
Mr. Vasut to close.
Thank you, Mr. Speaker. Members,
Mr. Speaker,
Ms. Gauls, for what purpose?
does the gentleman yield?
I will
Gentleman yield
certainly yield for
He
questions.
yields for questions.
Thank you, Representative Asut. I was just having a conversation with my Vice Chair, Representative De Ayala, and I was talking to him about how a lot of times when we're at the back mic, at the front mic, we say, okay, I'm going to ask you some questions for legislative intent.
Sure.
And then there's an exchange and we put it into the record.
Yes.
And while we recognize that that is not a vote of the body, we do recognize that it's the intent of the author, and that intent is then memorialized, and there is a vote of the body to put it into the record. Is that accurate?
There is if it is a motion to put into the record and that is adopted by the body, those remarks indeed are put in the journal.
So when we say, I'm going to ask questions for legislative intent, and we have that exchange, and we then put it into the record, I guess my question is we do lots of work in this building, and sometimes things can get lost in between lines. Why wouldn't we want to have all the tools in our legislative tool belt for people outside of this 150 body to understand what we're trying to implement or trying to do? Like, why take away this tool for us?
So the idea is not to take away legislative intent within the legislature. This bill is not going to have the effect of rendering meaningless the reduced to writing and placed in the journal, okay? But I want to make sure that we're thinking through this process. All sovereign power is vested in the people. The people have vested legislative power in the House and in the Senate, so that whenever we pass a law and the governor signs it or it otherwise comes into law over his veto, that is the legislative pronouncement of the people. That is what has the legal and force of law. That's what is to be enforced. And so all this bill does ensures that the words on that page control, okay? And that what we may have thought in between filing the bill and the bill becoming law is irrelevant for the enforcement of the law, but it is relevant for how the law comes about. So let me give you an example. If you were to reduce to writing and place in a journal these remarks, which always, we're probably going to do that. I just think that's funny. But if we did that, and let's say that was the intent, and let's say what I'm saying from the front microphone you thought was the intent of the legislation, you wanted to put it in the journal. Well, that's my intent as the bill author, and at most, though I might not agree with this, but at most, maybe that's the intent of the House when the bill goes to the Senate. That's not the intent of the Senate, because they're not here speaking. And so in that regards, the fact of the matter is, the only thing that is the true legislative intent is the words the legislature agrees to put on paper. So yes, the front microphone, back microphone dialogue informs the passage of the bill, or whether we think it's good policy or not. And maybe the Senate looks over here and thinks about whether it's good policy or not. But whether or not what the law means, just what you think or I think or the House thinks or the Senate thinks is irrelevant. What matters is what passes.
And maybe because we've been using this tool for a significant amount of time, I think for a lot of us members who have these conversations or trying to help the public understand or help the judiciary understand, we find value in this. And so I think that's why there's anxiety about, and I do hear your argument with Ernest. I see what you're saying, and there is some merit to it, but nonetheless, I do think that for decades, and I've been here for 13 years, we have been using this tool, even if superficially in some ways, but as a way to inform all the bodies and stakeholders of how we would like for this piece of legislation to be interpreted. And so I think this is why there is a lot of anxiety about your piece of legislation. And so I just want to thank you for answering my questions. I respectfully disagree, but I do see your point, but I do have a lot of anxiety about this. Thank you.
Anytime. Thank you, Representative.
Seeing host for what purpose?
Will the gentleman yield for questions?
Gentleman yield for questions.
I will yield for questions.
He yields for questions.
So we've been talking about what legislative intent how it's currently used by
Yes.
the courts and by the agencies and what your bill would do.
Yes.
So but I'm not clear. You're saying that it is basically irrelevant currently, and your bill is saying the same?
Well, what I would say is, under the current Code Construction Act, in certain circumstances, the courts can look to legislative intent, look beyond the words. And what this bill does is simply say that the courts are not to look beyond the words in any circumstance, but rather just give effect to the words used by the legislature. And to the conversation we had, you know, particularly with agencies, and I know that concerns were raised by Representative Rodriguez Ramos about agencies. I mean, what does this mean? Does this mean that all of a sudden all the rules passed by the agencies are voided? No. All this means is that when an agency is interpreting a statute about what the scope of their power is, they're supposed to give those words their plain and ordinary meaning. So if it said, adopt regulations about clean water, and that's all it said, then all of their regulations should be about clean water, not maybe clean air or some other subject, right? But we know that they have various statutes that give them power to adopt regulations across a whole host of areas. And so all this bill does is say that when the legislature has put into law a provision, that's to be given effect.
Okay. So, but that already happens, and the courts look where there is vagueness at the record to try to figure out what is exactly meant by statute. So I don't quite understand still the difference in how courts are how are they supposed to get meaning when there is vagueness if they can't look to the record and what our debate is?
So when they're looking at words, they give them their plain and ordinary meaning. And whatever is the plain and ordinary meaning that they can determine as best as they can. And in the legal process, we know what we do. We go and look first to the definitions in the bill, because those give specific meaning. And if they're not there, and we've got a word and we're not quite sure what it means, then we'll go to the English dictionary and we pick the construction that is in common parlance. And of course, a judgment call always has to be made by a court at some point in time on what the plain and ordinary meaning is. And this doesn't prevent them from doing that. In fact, what it does is says, pick the plain and ordinary meaning. And it'll be up to the court to do so.
So in picking the meaning, they can no longer look to our debate. They have to look to Webster's or
They have to look to common parlance.
common parlance.
So Webster's is an example. Merriam, you know, they go to the dictionaries. That's the classic. And what I want to put in context for you, this is not that much different than the current rules of statutory construction. It's just basically we are preventing a scenario where the court goes beyond the text and uses these back microphone conversations or the committee reports, right? We're just saying, look to the words on paper. If they're ambiguous, go to the dictionary.
Part of your bill addresses when part of the statute is struck down as unconstitutional, the rest of the statute remains in effect. So I'll give an example. If we passed the voucher bill here and there was a section of the bill at the very end that was the severability clause to provide for that language.
Yep.
That if part of the bill was struck down by the courts as being unconstitutional, the rest would remain in effect. That was important in that bill.
Yep.
A substantive part of that bill, because, for instance, there was a section of that bill that said the voucher couldn't be given to students who are unlawfully in this country.
Yes.
If the court finds that that is in violation of federal law because of Plyler v. Doe, then in fact the voucher will still be given to kids who are in this country unlawfully because of that severability clause. But that that severability clause is often not found in bills that we file. And so check me for understanding.
Sure.
Make sure I'm understanding correctly. Your bill now says the default of all legislation that we pass is that there is a severability clause in it, for instance, and the rest of the bill that is not found to be unconstitutional will remain in effect. Is that correct?
Yes, under the plain ordinary meaning of 311-0311, unless a statute contains a provision expressly providing for non-severability, then severability applies.
I think that's an important change in the law because I think we now will need to start looking at how we draft bills much differently. Would you agree that that is a substantive change in how we look at bills that we file because when you omit a part of your bill that you filed, it could have a completely different effect than if that part weren't omitted. So I just want to, are you checking the code?
Yeah, I'm seeing right
construction
now that
code?
there already are general savings clauses. As you know, basically there were some repealed in this bill and just replaced.
Okay.
Not much functional difference, but perhaps some. I'd have to look in detail about those two provisions. There's one in 312, one in 311, right? So, but the idea is that when we pass a statute, that's going to be given as much effect as possible based off of the words, so that if one part is held to be unconstitutional, any other discrete application or part can still be applied if it is constitutional, right? So the whole idea behind this is to ensure that the laws that we pass are given their maximum effect. Why? Because the people have vested legislative power in the House and the Senate, not in the courts.
But you're not sure whether the way we interpret statute already, or the way the default is to default belief that there is that the rest of the bill would remain in effect.
It just depends, right? So I'd have to look at a specific case scenario about how
Right.
the current savings clause impacts
Okay.
a bill without a savings clause. We'd have to run that
So
analysis.
this is my final question to
Yes,
you.
ma'am.
So does our dialogue here today on this bill count for purposes of court interpretation of this bill?
I don't believe so. But thank you, Representative.
Mr. Speaker,
Floor is for what purpose?
would the gentleman yield for a quick
Gentleman
question?
yield
You
for
for a
a
quick
quick
question.
question.
Yes, ma'am.
Okay, so did I just understand you to say there's a default severability clause in every piece of legislation with your bill, or not?
Well, with this bill, to every bill that it applies to, yes. Now, there's a provision in here that a statute could say that it is not severable. And if it says that, then of course this wouldn't apply.
Okay. Another question is, and you heard me say how difficult it is sometimes to be as precise as possible.
Sure.
And in drafting legislation, sometimes there are errors made. Is that not correct?
Sure.
And sometimes legislation that is passed, sometimes they have mistakes. Is that not correct? So haven't courts had to interpret, like if there has been a word, a key word omitted in a bill, doesn't the court have to say, well, they meant to say this because the sentence doesn't make sense the way it's written? That has happened before, has it not?
Yeah, it has happened, and the bill provides a mechanism for that. That's on page 6 of the bill, section 311.037. It's called a grammatical or scrivener's error.
Okay.
And there are particular provisions put in there for what a court is supposed to do when that happens.
Okay.
And basically, if it contains a grammatical or scrivener's error that would be apparent to an ordinary reader of the English language, they may interpret the statute consistent with the understanding of the statute by an ordinary reader of the English language. What that means is, if the average person picked it up and said, well, that can't possibly be right, and they clearly meant this other thing, then they could.
So
they
that
could do it.
would be allowed.
That would be allowed if it's a clear grammatical or scrivener's error. For example, they meant to say, I don't know,
a word that has a slight misspelling and means two different things. Does that make sense? Insert example, something like that.
Something, that's a simple explanation, but sometimes words get left out and it could be
Or the omission of a word, gives the sentence a clearly irrational meaning.
Opposite
and that's
meaning.
clearly a scrivener's error and right, in that narrow circumstance. Yes,
Okay.
ma'am.
All right, thank you.
Thank you, Representative.
Canals, for what purpose?
Mr. Speaker, I move that all the back and forth and dialogue on HB 113 be reduced to writing and placed in the journal for legislative intent.
Members, you've heard the motion. Is there objection? Chair is none so ordered. Mr. Martinez speaks for what purpose?
May we also take a big picture of Chair Vasut and reduce that to writing and place it in the journal for legislative intent?
Members, you've heard the motion. Is there objection? Chair is none so ordered.
Well, where some see gloom, I see hope. I see the people of this state having their legislative power that they've entrusted in us honored through this bill. I move passage.
Question occurs on final passage. Record vote. Clerk, ring the bell. It's Leo Wilson voting aye. Have all members voted? Have all members voted? There being 85 ayes and 58 nays, House Bill 113 is finally passed. Mr. Hunter for a motion.
Mr. Speaker, I move that the House